This honorable court will now resume its session. Please be seated.
All right, we'll proceed to hear argument in what was supposed to be the first case on calendar for argument this morning, which is 24-7282, Carly Ridings versus PeaceHealth Incorporated. We'll hear first from Mr. Jansen, but first I'd like to hear your explanation for being late to court this morning. So you received a notice that we start at 9 o'clock. You're told in the notice to arrive early and report to the courtroom deputy clerk before then. I could have called your case at 9 o'clock, heard from the other side, and held you to have waived your argument. We did not do that because we had other cases on the calendar. I allowed it to trail. But I'd like to hear your explanation for why you did not show up on time in an argument in the United States Court of Appeals.
Yes, Your Honor. I had a related case, I believe it was a Prakash case that we recently settled, and that was my first oral argument that I was going to be presenting, and that was starting at 10 a.m. And I apologize, I confused that.
Well, if you have a calendar conflict like that, you need to let the courtroom deputy know that. You need to let the other court know that you will be here and that we will take priority over anything else that you have in another court, unless it's the Supreme Court of the United States.
But that case settled, so I in my mind, I confused the 10-minute start time with this start time. So
okay. Well, I hope you'll understand that, you dodged a bullet, and I will allow you to have your argument. But something like this must never happen again.
Yes, Your Honor.
Okay. All right. Then you may proceed with your argument.
May it please the court. My name is Paul Jansen, representing the appellant Carly Ridings. I would like to reserve 2 minutes for rebuttal. This case presents a situation of clear error by the district court. My client had a religious exemption that had about 5 Bible verses. It was clear religious. The content of that exemption contains so much documentation of her religious convictions.
So, but why wasn't any of this put into the complaint? I mean, you have the exemption. You put it into the opposition to the motion to dismiss, but it wasn't put into the complaint. Why not?
Well, under the, there's a case, Koha versus Orexogen Therapeutics. When you cite something, you can cite something and incorporate that document by reference. So the complaint cited her religious exemption. And so under Twombly versus Iqbal, all that's required is basically a very simple statement of just sufficient to show entitlement to relief. And under the UC versus Abercrombie decision, the Supreme Court held that standard was very low. Even simply providing just someone walking into the room with a hijab was sufficient to put the defendant on notice that accommodation might be required. Here, not only does the complaint allege that she submitted a religious accommodation, it also alleges that the defendants received that accommodation and accepted it and said, yes, we're going to accommodate you based on this religious exemption, and your accommodation is indefinite unpaid leave.
Your answer is a bit of a shift from Judge Collins' question. I think it starts really with the incorporation by reference doctrine. If we agree with you that the incorporation by reference doctrine applies in this case, don't you win the case because you have much more in that document than the complaint?
Absolutely.
Okay, and you say that's something that we should consider and hold, that the incorporation doctrine applies.
Absolutely.
Okay.
Even if the incorporation by reference doctrine does not apply, though, we still have sufficient basis to win here because, first of all, the EEOC versus Abercrombie substantially lowered the pleading standard to plead religious beliefs. It eliminated the explicit notice requirement. So any kind of actual constructive or inquiry notice is sufficient to put the defendant on notice of a person's religious conflict with an employer requirement.
And are you taking Detweiler into account in making your argument?
Yes. So Detweiler, first of all, Detweiler dealt with a specific situation where someone was essentially, they had an objection based on carcinogenicity of a nasal swab test. And the court said that that was a secular preference. It wasn't a religious issue. But this is not a case like that. This is a case where my client stated that she had an objection based on the fact there was aborted fetal tissue used for constructing and manufacturing the vaccines. And so in almost every court in this district that has looked at exemptions like that, they have upheld those exemptions as valid.
But those district court decisions are pre-Detweiler, though.
Yes, but Detweiler did not deal with fetal tissue, a fetal tissue exemption. Detweiler dealt with an exemption that was about, that was alleging body is my temple. The argument...
But we wouldn't, if we don't consider the request, we wouldn't know the basis that's based on fetal cell objections, right?
So if you don't consider that request, then we would have to consider whether the court erred in granting leave to amend to consider that. And I believe the court basically looked at the religious exemption and said that amendment would be futile because the religious exemption was insufficient. And so that's certainly problematic that the court would grant the motion to dismiss and then not allow leave to amend and not allow the introduction of
You
that religious
specifically
exemption.
asked for leave to amend in your opposition?
Yes, we've asked for, my understanding is we asked for that every time, but even if we hadn't specifically requested that, that would be something that the court should have allowed. And it would have been an abuse of discretion not to allow amendments specifically because that highly detailed religious exemption was presented to the court in the process of the motion to dismiss pleadings.
And do you feel you've preserved the argument about leave to amend in your briefing on appeal?
Yes. So there's some specific case law on this that on Bolker versus Commissioner 760 F2D 1039, the Ninth Circuit 1985, where, for example, if there's issues that are purely legal, whether, for example, whether the exemption letter may be considered or whether the complaint states a plausible claim or whether amendment should be allowed, then those issues can be brought in a reply brief. Also, they respond to the issues raised in the answering brief. So the defendants in their answering brief stated that the exemption letter should be ignored. They said that the state complaint lacks factual detail and Detweiler requires dismissal. So the response and the statements in the reply brief were responding to that. And finally, the case law that we're talking about is distinguishable here because whether or not an amendment, a judge should have granted leave to amend rather than just simply dismissing a case with prejudice, that is inextricably tied to the fundamental merit arguments of that motion to dismiss. And so the case law they were citing was involving, bringing in brand new arguments about totally different claims or legal reasoning. And so that case is distinguishable. And finally, the Ninth Circuit disfavors striking arguments absent prejudice. So United States versus ULA, 976 F2D 509, page 514, Ninth Circuit 1992. So the court should be reticent to do so. Finally, looking at Detweiler, with the procedural posture with Detweiler currently is that there's a petition for en banc review pending with Detweiler. And I would encourage the court to review that, but also I want to point out that while it is distinguishable, first of all, it talks about body as my temple exemptions, not fetal tissue exemptions. And there's about basically 50% of the exemptions in these types of cases, which we've litigated a lot, were body as my temple exemptions, where the person is saying, look, I believe my body is a temple of the Holy Spirit, and I believe there's that the vaccine is going to harm me, and so therefore I can't take the vaccine. The other 50% of those exemptions were, I think the vaccines were manufactured or contain fetal tissue, and so I don't want to take the vaccine for that reason.
Okay.
And
Do
so,
you want to save time for rebuttal? Because you have under 2 minutes left.
oh yeah,
Okay.
I apologize. I do want to do that. I just want to make sure I do a couple more arguments here and then we'll wrap it up.
That's your rebuttal time. So
Okay.
I suggest you save the rest of your time if you want it.
Okay. Yeah. I just want to address one thing with Detweiler, and I think I want to raise the issue that it's under Larson versus Valente and Edwards, Bartolo Cart versus Florida Gulf Coast Building and Construction Trades Council. These issues regarding the scrutinizing the content of a person's religious exemption raises First Amendment problems with the Establishment Clause, the Free Exercise Clause, and the Free Speech Clause, because we're looking at rejecting someone's religious beliefs based on their content and their viewpoint. And that's a very serious concern in these types of cases that needs to be analyzed and considered by the court. Thank you. I'll reserve the last 15 seconds for rebuttal.
All right, then we will hear now from Mr. Garone.
May it please the court, counsel. Plaintiff's complaint contains only a threadbare and unadorned conclusion that her religion prevented her from taking the COVID-19 vaccine.
Well, but the plaintiff filed an opposition in which the plaintiff also submitted a declaration that it attached the request, and it's extensively quoted in there. And then the opposition, points out that you can't grant this Rule 12 motion, unless there's no chance it could be cured by amendment. And then the district court does this very odd thing, which is it's dismissed without prejudice, and the clerk is directed to enter judgment, which is just bizarre. If the complaint is being dismissed without prejudice under Iqbal, it's almost a fortiori on a first motion that you have to grant leave to amend. And I can't fathom what the district court did. Why was judgment entered to be directed without prejudice?
Yeah, Your Honor, I can't read the district court's mind on that one either, but I would say this.
It seems on its face reversible error.
It was never assigned as error in the opening brief, and we have a motion to strike that is pending before this court, Your Honor, or before this panel, with regards to this issue that he should have been granted leave to amend, because the issue of whether the complaint should have been dismissed in its unadorned form, where it has one sentence, conclusory sentence about religion, is different from the issue as to whether he should be granted leave to replead. And one would think that in your opening brief, if you're complaining about being denied leave to replead, that you would identify that as an independent issue, which it is a separate issue, Your Honor. And
but
so
it's not
it's waived.
jurisdictional, and we have discretion to notice what is an obvious, on the face of the district court, error. You cannot dismiss a case without prejudice for failure to satisfy Iqbal without granting leave to amend, particularly when it's in the opposition. I don't think I've ever seen a Iqbal grant of a motion to dismiss and then order the clerk to enter judgment without prejudice and say nothing about leave to amend. I can't unsee it.
Well, Your Honor, the plaintiff had options to try to remedy that situation. For instance, he could have filed a motion under FRCP 60.
He could have, but he could also, given that the district court stuck him with a judgment, he can appeal it to us.
He can, Your Honor, that's true, but I don't think he's preserved that error. And I think in any event, even with the letter that was not, by the way, incorporated by reference in the
But
complaint.
suppose we're not, just hypothetically, suppose we don't agree with you on that. And we're going to say that the district court should have considered the letter essentially as a proffer of what the complaint could say if it's amended, which is a very rational way to read this, that if I put a letter in with my opposition, that's what I could say in the complaint if afforded leave to amend.
Correct.
So then if we take that into account and we measure it against Iqbal, tell me why you think it still falls short of Iqbal if you believe that.
I do believe that, Your Honor, and for several reasons. Number one, if you read the letter carefully, it begins with 4 bullet points, which can be found at ER 51. Those 4 bullet points contain a statement of secular safety concerns about the effects of the vaccine on pregnant women based upon plaintiffs' views on the newness of the vaccine, lack of clinical trials for pregnant women, and the possibility of adverse reactions. That's, in essence, the first page of the letter. Plaintiff then states that because of these safety concerns that were expressed in those first 4 bullet points, she cannot take the vaccine because of her religious belief that her body is a temple.
Well, can you address the second to last bullet point? Says, though the aborted cells used to create vaccinations in the 70s, 80s, may be far removed from today's vaccine, they still originate from those aborted children. The practice of using an aborted child's body for science against his will violates my religious conscience.
Yes.
And then contrast that with footnote 2 in Detweiler, where we say that's enough.
Right. Well, Your Honor, first, I will get to that, but the body as a temple thing is kind of foreclosed by Detweiler. So
Well, but we're looking at that
going
that
to
one,
your
yes.
question, first, she never says in the letter that she has a religious objection to abortion. Second, she references
Violates my religious conscience and cites Jeremiah 1:5. I'm not sure how that's not based on her religious beliefs.
she references, Your Honor, aborted fetal cell lines being used to create vaccines in the 1970s and 1980s, and never states that these lines were used to create the COVID-19 vaccine. Third, she admits that these older vaccines are far removed from today's
vaccine. We have
vaccine.
to read, if we're to treat this as something that's in the Iqbal hopper that we have to consider, then we have to read the allegations in the light most favorable to the plaintiff. And under Iqbal itself, we draw reasonable inferences from them. It's certainly a reasonable inference from this that she's asserting that the COVID vaccines were derived from these, because why else is she mentioned? Oh, let me just mention some irrelevant fact about, aborted lines. Of course, the reasonable reading of this is that these were used in the COVID vaccines. You may disagree with that, but that's the reasonable reading of the assertion, and that she has a religious objection based on opposition to abortion to using a medication derived from aborted fetuses. Why isn't that a reasonable reading of this bullet point?
Well, Iqbal, Your Honor, sets forth a plausibility standard as opposed to a possibility standard. And I agree that reading that language, it's possible that that's what she was referring to. But if you read the actual language of what's in her letter, she's talking about fetal cell lines in the 1970s and 80s. In the context of the entire letter, the gist of the entire letter is that she was concerned about the effect of the vaccine on her unborn child and on herself due to her pregnancy. That's kind of the gist of it. This, in our minds, is kind of under Detweiler, is more or less a broad invocation. It's not a specific objection based upon her religious objection to abortion. She never says that she has a religious objection to abortion, and she never specifically says that the COVID-19 vaccines were derived from fetal line cells that were derived from aborted fetuses. So yeah, you're reading between the lines, and I would submit that it is not a reasonable inference. There's a possibility that's what she meant, but that is not what she says in the letter. And Your Honor, I still think that that we have to look at preservation here. I mean, there's the whole issue of whether that letter was incorporated by reference, I think, was never raised in the brief, the opening brief. And by the way, several of the cases cited by counsel today in his opening argument are not found in any of the briefs. They're not found in any 28F letter submitted to this court, so we don't have the benefit of having, read his argument about those particular cases. But, and then of course we have the issue of him never raising the issue of being given leave to replead in his brief. So the whole purpose of appellate advocacy is to have issue-driven advocacy, where you file a brief, you set forth your arguments, and you give the opposing side an opportunity to weigh in on those arguments. And here that wasn't done. When we filed a motion to strike, I was under the impression that Mr. Jansen was okay with striking the portion of the brief about leave to replead, but it certainly isn't in his brief. And so we would ask the court to strike that, to hold counsel to the type of issue-driven advocacy that Rule 28 of Federal Rule Appellate Procedure 28 requires, that you lay out your arguments in your brief. And there is no argument in that brief. There's one reference to the incorporation by reference doctrine in a footnote, and that's it. So it's our position, Your Honor, that you should not consider the letter, and you should not consider any argument that he should be given a chance to replead, because it's not put forth in his brief, and it's waived. And I grant the court has discretion to do these things, but these rules mean something. These rules of advocacy and proper appellate procedure do mean something. And when you just...
This isn't an issue with great surprise, where somebody raises an entirely unrelated line of argument. I mean, this is Iqbal, where he's already trying in the opposition to get the letter in, and he asked for leave to amend. It's obvious, and you know that that's in the mix of issues, so you were not surprised by the fact that you have to address the letter.
But again, Your Honor, I guess the way you're framing the question, I guess I'd come back to it's harmless error, in the sense that we still don't think the letter... That
I understand. That's agreed. But when we would exercise discretion on whether to overlook, a forfeiture, one of the big issues is prejudice. Is there genuine surprise? Like, oh my goodness, that I didn't know you were going to raise that. This isn't in that ballpark, because this is in the opposition below. It's in the guise of incorporation by reference. So the substance of this is something you already met in the district court, you're meeting here, and so you're not prejudiced in the way that you would normally look at.
I guess I would quarrel a little bit with that, because if it was raised distinctly in the opening brief, there is a lot of case law about incorporation by reference, and the case that counsel cited, I think, says that the doctrine is easy to state but can be very hard to apply. And there's a lot of cases from the Ninth Circuit where the court wrestles with whether a document was properly incorporated by reference. So if it had been raised, I think we would have had a more robust opportunity to plead it, or to brief it in our response brief. But I guess I would leave the court with this. We don't think that the allegation with regards to the fetal cell lines rises to the level of plausibility under Iqbal, and it's mere possibility. And so even if they were allowed a chance to replead and add that, we still think that the motion to dismiss should have been granted. Thank you, Your Honors.
All right. Thank you, counsel. All right, we'll hear rebuttal. Although you did not save time, even though I was trying to warn you about that, we did take your opposing counsel over, so we gave him more time, so I will give you the 2 minutes you had requested.
Okay, thank you, Your Honor. So our position is that we provided defendants with, defendant in this case, with substantial evidence of our intent to assert arguments about failure to amend, and I believe we requested amendment in our opposition to the motion to dismiss.
Right, but his argument is you didn't put it in the opening brief. It's in the, I checked, it's in the opposition. You do cite the Rule 15 standard and the rule that you can't dismiss the case without giving me leave to replead unless it's impossible. But where is that in the opening brief? That's his point.
Yes, so the opening brief does have that footnote about incorporation by reference.
No, but this isn't incorporation. This is amend. If you don't buy my incorporation by reference is it's already in the complaint. Right. Not that it needs to be amended, it's really already there. But did you argue in the opening brief, I should have been granted leave to replead, to add in additional allegations to meet the Iqbal test?
No, we didn't specifically argue that in the opening brief, but what I believe is reasonable here, Your Honor, is that that is expected. Basically, if we're arguing that the judge was wrong in dismissing the case, and we're arguing it's wrong by failing to consider the religious exemption, then by implication, the judge was wrong by failing to give leave to amend. And so this is not an argument that is something that the defendant didn't have notice of or didn't have an opportunity to, or was surprised about us raising in the reply brief. And it's definitely something that they got the opportunity to argue today and to respond to today during oral argument. So I don't think there's prejudice there for us to be able to continue to raise that.
All right. All right. Thank you, counsel. The case just argued will be submitted, and the